So Congress has tried on and off for years now to enact some kind of a national data breach reporting standard and have not had much luck in getting that across the finish line. That momentum seems to have shifted a bit in the past few months, given the massive SolarWinds breach, the range of companies that affected and federal government agencies that affected. And it seems to have really re-energized this effort to reach some kind of legislation that can get passed in Congress. Even in February, at a Senate hearing on the SolarWinds breach, you had Microsoft President Brad Smith saying, and I quote, "It is time not only to talk about, but to find a way to impose in an appropriate manner some kind of notification obligation on entities in the private sector." He went on to say, "It's not a typical step when somebody comes and says, place a new law on me, put it on ourselves, put it on our customers." But he said, "But I think it's the only way we're going to protect the country and the world." And as he pointed out, you don't usually have a company coming and saying, yes, give me more government requirements that I'm obligated to follow. But some of the things that maybe limited the ability for this legislation to get passed in the past may have shifted a bit. And the concerns that companies had about reporting something that would then trigger an investor lawsuit or trigger bad publicity, that calculus may be shifting a little bit. And so we're going to spend the next 45 minutes talking a little bit more about how we got here and what you all see as the path forward. We're joined today by three panelists at the very center of this conversation. From the Justice Department, Adam Hickey, who's the Deputy Assistant Attorney General for National Security. From the FBI, we have Tanya Ugoretz, who runs the FBI's Cyber Division. And from the private sector, Luke Dembosky, partner at Debevoise and Plimpton, who counsels companies dealing with breaches and is also a former senior Justice Department official who oversaw the government's national security cyber prosecutions. So great to be with you today. So maybe to start, let's sort of set the scene a little bit. Luke, maybe can you walk us through what the reporting landscape looks like right now when a company does experience a hack of some sort and the theft of personal consumer information? Who do they have to report to? What kind of information do they have to share? What is the calculation that they go through? What's the analysis?
Absolutely, Aruna, and thank you for moderating, and thanks to RSA for the chance to be on the panel. It is quite a patchwork that we have of breach notification laws. I'm glad that you specified consumer or personal data because that's the major part of the equation, but it's only part of it. In the United States, we have 50 state and 4 territorial separate breach notification laws. And so each one of these sets ground rules on when a party doing business in the state has to make a report to individuals and perhaps a second report to state authorities based on a suspected unauthorized access to or acquisition of personal data of an individual. And so it's very challenging for companies that do business across state lines often to figure out, what are all the various potential breach notification obligations. It's very intensive on legal analysis. It involves identifying what states people are residing in, whether they have a second residence somewhere else that should be taken into consideration. And all of that is only just within the United States alone. Europe stepped into the fray in a very big way by passing the General Data Protection Regulation, the GDPR. It went into effect in May of 2018. And the one positive thing about it, or one of the positive things, is that it does set a uniform breach notification standard as to personal data across the EU member states. And now with the UK post-Brexit, they've followed the same regime as GDPR, at least for the time being. And so really just 2 jurisdictions, the United States and Europe, can lead to a lot of complexity in the notification decision process.
Adam, what does that look like from your perspective, from the federal government perspective? Given this patchwork, do you just not hear about are there breaches you hear about way after the fact that you wish you had learned about sooner?
I think that's right. I think these laws come from a good place, which is a desire to protect certain consumer rights, and impulse that if data relating to you, particularly sensitive data, is lost, that you ought to know about it, perhaps so you can protect yourself better, perhaps so that an enforcement action can be brought because somehow that loss is a result of negligence. But over the last few years, from the federal government perspective, we've seen a number of circumstances where critical infrastructure has been impacted by a breach, or the impact of the breach is so sweeping that it's impacting multiple sectors, potentially thousands of victims. And we are challenged in getting a handle on the visibility of what's happening. How widespread is a particular form of ransomware? How many companies or entities have been impacted by the exploitation of a particular vulnerability in a very commonly used product? And so, in addition to the challenges that Luke's raised, which I think are very real ones from the standpoint of the private sector, which is complying with a patchwork of obligations, there's a second reason to think about this issue, which is there another value we should be concerned with, or other equities like protecting national security that could be served by a national data breach reporting requirement of some sort? And obviously this administration hasn't yet taken a position, at least at the time of taping, on whether and how that should look. But certainly the federal government has periodically advocated for that kind of reform in the past. And so that's why I think this conversation is relevant now, increasingly relevant now.
Sure. And you bring up the increasing national security reasons for this. I think the SolarWinds breach did kind of underscore that incentive behind this legislation. Luke, you were involved in helping the company respond to that breach and interface with the government. Can you talk to us about how the existing reporting requirement landscape may have influenced what they did, or did what they do have very little to do with the existing requirements?
Yeah, I think it had very little to do with it because it was obviously an urgent matter. The company made a decision to come out very quickly, very proactively. And I think, beyond that has been, by most all accounts, or all accounts that I'm aware of, very transparent. And so the company's put out a lot of things publicly about exactly what happened, exactly the threat indicators involved. That's, been shared thoroughly across the board, broadly with the government and the public sector. And also, it's a global event. So the transparency's not been limited just to the US, but to stakeholders around the world to try to react proactively. I think it raises that sort of thing. Aruna raises an interesting distinction from where we started, because that incident's really not so much about personal information or personal data. The laws that Adam and I started out commenting on really are about consumer personal data, and were originally driven largely by privacy concerns and identity theft concerns of individuals, mainly in the US, identity theft, and then it expanded as European concepts and other concepts of data privacy have worked their way in. I think these larger issues, including the Microsoft matter, they address things involving, for example, critical infrastructure. And that's a different type of reporting than reports about personal data. In the EU, there was a law passed alongside GDPR, but no one really has talked much about it publicly, certainly in the US, called the NIS Directive. This sets a very short time window for critical infrastructure companies in Europe to report any potentially significant incident to regulators. And that one is really not about privacy or identity theft. It's about effects on critical infrastructure and national security much more broadly.
I do want to come back and talk more about the European regime, and we'll ask you if you've counseled companies responding to that infrastructure piece of things. But Tanya, let me come to you first. And from the FBI perspective, can you talk about, you obviously are dealing with a lot of different companies that do face breaches and have to come talk to the FBI about it. How would you compare SolarWinds' very quick public response to sort of the other companies that you're dealing with, just as a general matter?
Thanks. I think the SolarWinds incident is really interesting because a lot of times when we see a groundswell for legislation or to close a particular gap, like we're starting to see with the National Data Breach Reporting Law, that groundswell is prompted by something that didn't happen, someone who didn't take an action or didn't tie information together or report something. And here we have the opposite case. We actually have an incident where, from the standpoint of the actions of FireEye in particular in reporting the intrusion, all the stars aligned. They did the right thing from the government's perspective. Almost immediately upon noticing that they were the victim of this very sophisticated intrusion, they reached out to the government. And I think, that was extraordinary in how they did that. And I think it highlights what we often, unfortunately, don't see. And when I say that the stars aligned, I mean, this is a case where the victim is itself a sophisticated cybersecurity company who is more accustomed than many private sector victims to being able to recognize intrusions and recognize when they're seeing something that looks like it's going to have impact not only on them as an individual victim, but is likely, part of a much larger campaign, meaning that, the national security interest was high. And so it was very important that they come to the government quickly, but we can't count on that happening in all cases. And so I think that really highlights, has highlighted for many the need for this type of national data breach reporting. I think it also shows the importance of some of the kind of proactive relationship building that the government does with members of the private sector, whether that's members of the cybersecurity community, like a FireEye, or the rest of the private sector, both small and large businesses and the whole range of the sector. It's that proactive relationship building that raises the likelihood that a victim of a cyber intrusion is going to report that to the government. And that takes many forms, from kind of routine information sharing to some of the hubs, such as the FBI has established, where members of the private sector in certain industries are sitting side by side with FBI employees, looking at logs and threat-related data, and trying to increase the speed with which we can act on what members of the private sector are seeing from a threat perspective.
Hey, Tanya, I think there's a point worth emphasizing in what you said, which is FireEye's reporting of this mattered not just because it was good for the government to do its job, right? Our job is to investigate breaches and figure them out. It's that, in an apparent likely espionage campaign in which something in the vicinity of 18,000 or so systems were exposed, we think far fewer were actually exploited, right? That data was stolen from them, far, far fewer than that. And part of the reason for that is perhaps that we caught this earlier than we otherwise would have, thanks in part to one victim, one very sophisticated victim, raising their hand and saying, this is happening on my network. And had they not done that, I can't say for certain I know when we would have otherwise unraveled this. And so the kind of reporting requirement we're talking about here doesn't just make us feel better as agents and prosecutors because, now we can open a case now versus 6 months from now. It's that knowing what's happening nationwide is critical to our ability to push out the information that helps people protect themselves, other potential victims, the folks who have been victimized who also don't even know about it.
So it sounds like what you all are saying is that in a new national data breach reporting law, you almost want to incentivize every other company to do exactly what FireEye did in this instance. Is that right? Or do you think legislation would have changed at all how they responded here?
I think what Tanya and I are saying is that was model behavior and it was entirely voluntary and it's in the public good. And sometimes you want legislation that creates those incentives so that what was purely voluntary today is encouraged in the future or potentially required. And that's a choice, obviously, for the administration and Congress to make. But that's what we're saying. We're saying this anecdote demonstrates why that kind of reporting is so important. So let's make it easier. Let's make it mandatory. Let's encourage it. Whatever combination of carrots and sticks comes out of the policy process. It's helpful.
Right. Adam, you had mentioned this sort of shift in even reasoning behind this law in the growing national security concerns. Are you seeing any shift in how receptive companies are to coming to talk to you if they are concerned that the actor they're dealing with is a potential nation state versus maybe just a general ransomware or criminal type attack?
Yeah, that's a good distinction you're making, and a great question. And I want to hear what Luke has to say too in response to that, because he represents folks who are making exactly that decision. My sense is, as a general rule, companies are more willing to contact the government and work with law enforcement now than they were ever before for a few reasons. One is that having a data breach alone used to be a kind of a scarlet letter, and there was a shame factor, and so you kind of didn't want it to get out. Now there's sort of a sad understanding that this is a sort of part of the mortality of computer networks that this happens. And so then the attention turns not just to defense, but resilience and reputation. And part of the way you demonstrate you are taking something seriously and doing everything you can as a business is saying, I'm working with law enforcement to address it. I do think there's a potential distinction between the breaches that are ultimately going to become public because of these very state data breach reporting requirements, right? Or something that is too big to go unnoticed versus the kind of intrusion that the company, like ransomware potentially, might be tempted to hope never sees the light of day. And so I do think companies think harder about coming to law enforcement if they think there's a chance no one will ever know about it. The argument we make, in addition to the fact that we think you'll want to say you're working with us, is that by working with us, you do get the benefit of some context and information from the FBI and the FBI's partners across the government. So that's a nuanced argument, right? After the breach has happened, Tanya and I can't come in and say we can make everything better like it never happened. What we're offering is a bit more insight, potentially a bit more context, another partner in this. But some counsel have said, to me, listen, I don't really care whether it's a state actor or a criminal. The network's been breached, so attribution doesn't really matter to me. I think that's short-sighted. I think nation states generally have different objectives, and even if criminal groups are very sophisticated, there's still a different framework that most state actors are operating with. And even if it's one or the other, don't you want to have more information about them? I think the other factor that's helped us is, I think we've disabused people of the notion that by reporting to us, there's a one-size-fits-all solution, or that we're going to walk in, take over the investigation, make impositions on you and your staff. We're going to be really sensitive to what is public, what is not public, what your time frame is for reporting things. We're not your regulator. We're not there to go tattling on you to your regulator. So I think we've gone a long way in sort of softening the image of law enforcement, if I can use that term. But there are still folks who say, listen, what's in it for me?
Luke, how do you see it from your perspective? Is there some increased desire to talk to law enforcement, or is it still pretty much only if we have to, we'll go?
No, I think it's changing. It's, as Adam said, it's less now about the fact that you had a breach. As we talk to many companies, most all of them have had some breach, in their history, sometimes recent history. And so they're aware of, how painfully challenging it can be to avoid a compromise. And if it's a sophisticated enough adversary like a nation state, and they're determined and they have basically unlimited resources and time, they've proven time and time again that they can get into the hardest of targets, including, in the intelligence community of the US government, for example. So no one really is impervious to attack. And so there's a level of humility about all of this that has crept in. And so it's devolved more to what I think is a better, healthier way to look at this, which is, how did you respond? How did you respond? And there's the initial coming forward when you've discovered something, as you noted that FireEye did. There's also what a victim like SolarWinds does in terms of the quality of the information that they share and transparency toward customers and the government and so forth. Because you could check a box and make a notification from a compliance standpoint, but unless you're proactive and transparent in the cards you're willing to put onto the table, showing the world taking ownership of the issue, then the ability of the government and the ability of other would-be victims to prevent this, is really limited. They're going to have to start from scratch unless you lay it out for them. And so I'm finding refreshingly that when we have a client, for example, that has an incident, and increasingly it's been something like ransomware, where it's people know about your problem pretty quickly. It's not something that's low and slow, as we say. I find myself, with the client on the phone or on the video with their largest clients, corporate clients, who are very sophisticated, and they're not saying, why did this happen? How did this happen? They want to know what happened, how it can be prevented, what you're doing going forward, whether their data, of course, is safe. And we often find that transparency is leading to a lot of goodwill, just to say. I mean, we all wish that it hadn't happened, but if we're going to be here, we've shown who we are by coming forward and putting cards on the table with a lot of transparency to the fullest extent we can.
So there have been several congressional offices that have started thinking about what new legislation in this area might look like. We've seen some reports of more general laws about having a broad range of companies reporting incidents. We've seen some more specifically tailored to companies that are in infrastructure that is deemed to be of national security importance, reporting more specific information about their data breaches. Tanya, from the FBI perspective, can you talk to us a bit about what the FBI would like to see in some legislation that ends up coming together?
Well, I think, the important thing is that, we want to make the reporting requirements as clear as possible, as clear and easy. So I think you heard Luke describe at the outset why that's not currently the case. So I think that's idea of standardization and giving companies kind of less to figure out at the moment that they're suffering an intrusion, and making it as easy as possible is really the key first part. I think it's also important to say that, in the sense that some folks are worried that this might be a burdensome requirement, either on the private sector or on the government to manage what might be kind of inbound from this increased reporting. As Adam articulated, I don't think we're looking at a threshold where every single incident and intrusion would need to be reported. What we're most concerned about from the federal government perspective are incidents where there's a national security or public safety concern. So things like US government information that's been threatened, or US critical infrastructure. And I think, we have ways and established, kind of procedures and processes here where we can take that information in, triage it, analyze it, find the connections, and as Luke described, be able to provide information back that's not only going to help answer those questions of, how do I keep this from happening to me again? But it's also, providing us information that we're going to be able to provide to others to help keep them from being victimized.
Luke, how about from the private sector perspective? What do you think is most important to see in legislation?
I think, Tanya's hit the nail on the head in terms of clear lines. I think if it's seen as sort of just another compliance layer and not so meaningful in the scheme of things, people of course will do what's required, but it won't be viewed as favorably. One of the things that I think has played out well in Europe on the NIS directive is that it sets a pretty clear high bar. It defines the sectors, although that's been a little bit hard to tell who's in and who's out of scope. There's been some guidance on that that's been very helpful from European regulators, but it creates that channel. It establishes a rapport of trust. What's been happening in the U.S. that's been very favorable, going back to what Adam said early on, is there's been a huge effort by the FBI, the Secret Service, DOJ, to change the whole dynamic with victims, to treat them as victims. And I think as long as that message carries through with what's being done, it will be viewed very favorably. I think if, to the extent the law helps others in the community more broadly avert harm, it'll be viewed very positively. To the extent the information reported goes into a black hole or a vacuum and nothing comes out of it that anyone can perceive anyway, it'll be viewed as sort of another check the box exercise. And I think that's what we're all hoping to avoid.
Do you think there are lessons from the European model that Congress should take into account now?
Yeah, it's got a simplicity to it. So I like that, if it's just like your incident response plan, if it's a 200-page door stopper, it's going to be a great door stopper in the crisis, but no one's really going to read it. It's the same sometimes with these laws. Your lawyers may read it, but the people who are your operators and seeing things, it becomes challenging to enforce it. So I think bright lines, clear communications pathways, clear returns on information, in other words, clear benefits not only to the reporting victim, but to others, say, in the sector or more broadly, will make it very effective in the scheme of things.
I think Luke makes a great point about that need to show that this reporting isn't just going into a black hole, or it's not just coming into some database that, the federal government is poring over for its own purposes and then not acting on. As we, envision what this would look like, having that reporting come in would be the start of the process, not the end of it. Because, from the FBI's perspective, we would be looking at it in terms of how do we act on it? How do we tie it together to other adversary activity we might be seeing? How do we set leads to our field offices to go respond to the entity that's reported it? How do we take what we're learning and then, share it out with others? We think of, this is going to sound morbid to pick up on Adam's word, but we think of each of these intrusions as if, it were a murder conducted by a serial killer. Whoever's behind it will strike again, and they're leaving clues at each crime scene. So this reporting will help us pick up those clues and share it with others before they then become a subsequent victim. So I think it's really, that action that's going to occur after the reporting comes in that's would make this such a game changer.
Yeah, I mean, Aruna, I don't want to presume anything, but I know that when there are some private sector reports that come out every year that are essentially surveys of data breaches, means and methods, trends over time. I read them because it's critically important that we know what the landscape looks like. I think if this reporting led to public reports by the government that were aggregated data, that alone would be very helpful to industry, to the security providers who see a segment, right? They see their customer base, they see the clients, but that's one way the government could contribute from this. The other thing that being told what to report and when does is it helps remove some of the, I think, call it ethical, call it strategic considerations that companies have to make now about, I would like to report this, but maybe there are disadvantages or advantages. And there may be a competitive disadvantage, right, in their mind to doing it. Luke, tell me what you think, but I think that if there's a standard that's clear that everyone's following, as a business, it makes it easier for you because you're not following one set of rules that your competitors or others that seek to be competitors in the marketplace aren't necessarily going to follow. So it might put you at a better position, or at least at a level playing field.
Yeah, I think that's right. If those goals could be accomplished, I think people will embrace it. I think there's also been some innovative thinking in this general area. One is the CISA Act from 2015, where you had things like protection from liability, from privilege waiver. Those sorts of things are important to companies. We've seen other examples at the state level. Just switching over momentarily to the personal data breach reporting regimes, Ohio, for example, came up with a safe harbor around their breach reporting, whereby if you can show certain reasonable security measures were in place, you've got a protection from liability. I don't know that any of these things is perfect or has worked out perfectly in practice, but that's the kind of thing that I think would really incentivize industry, not only just to tell you what happened, but to invest more, even more, in preventing it from happening again.
How would you envision enforcement of a new federal standard working? Right now, obviously, we've got state laws enforced by state attorneys general. Would you envision a new federal law preempting all of that and then being enforced by the FTC? Or how do you envision that? I don't know, Luke, if you want to weigh in on that.
Sure, I could start briefly. So I think it's a challenge because, we tried to do something like this in the Obama administration, as we said at the beginning of the program. And it was challenging enough then. That's going back 7 or so years ago when that was percolating. And I know there have been efforts since then. But each year that goes by, the state laws get built out even further. The state enforcement apparatuses get more robust. The cyber and privacy issues rise even higher up the priority scale within those state and local agencies. And so it becomes harder to think about preemption and unwinding that. I almost think you'd sort of have to decouple the standard. Maybe you would have a standard reporting time frame, standard definition for personal data, standard set of exceptions, all the patchwork that we deal with now, where lawyers sit there with beads on an abacus, as I sometimes say, and slide them around to great expense for their client because that's what we have to deal with. If there were one standard, you could think about that being the preemption component, but that the enforcement would remain at the state level. Because I think taking that away from the states at this point is going to be very challenging.
That does definitely make a lot of sense. Tanya, how would you envision the reporting coming in? Would you even envision like a new joint FBI DHS kind of office to take all this in and then sort of farm out the tips and leads, or what would you like to see there?
Yeah, I think there's a few different ways that could work. As I mentioned earlier, I mean, we certainly have the structure in place just in terms of, how we take in tips and reports, whether that's, through phone lines or websites or our Internet Crime Complaint Center. I mean, for many different types of threats and crimes, there's many ways that we ingest that type of reporting and are able, as I mentioned, to kind of triage it and act on it. I think we're less concerned about who would own that and who the initial recipient in the federal government would be than we are about who can view it simultaneously, so that there's no delay in being able to act on it. So when I think of the primary federal agencies who would need to have that type of kind of real-time, unfiltered visibility to what's coming in, I think those primary agencies are the two that have the lead responsibility for incident response when it comes to cyber incidents, which is the FBI and CISA. Our roles are very complementary, and we work together really closer now than we ever have in terms of our threat response, responding to the kind of national security and investigative needs of an incident, and CISA's asset response role of mitigation and recovery. And so I think if we're both able to look at the data, coordinate, and act quickly, that's really the primary concern, and we can work out the details of where it's housed and who's responsible for managing it.
Would you potentially be concerned that you'd be getting hundreds of tips like a week, or reports sort of every week, almost potentially even every day? Is this potentially a case where the government is just going to be flooded with almost too much information?
Well, first, I'd say it's a problem we'd love to have. I think if you compare the current situation we're in, where we can't even quantify really what we're missing. So I'll say that first. I don't think we're concerned about that for the reasons I mentioned earlier. Every kind of discussion and draft legislation I've seen on this so far does not, is careful to set a threshold, I think, for the types of reporting that the federal government would be most interested in terms of the types of entities being affected, going beyond the personally identifiable information, those types of data breaches, to those potentially impacting the security of US government information or the security of critical infrastructure. Those are still very large categories, but I'm confident that the government would be able to handle that reporting. Where I would have a resource concern, but one that I think could be addressed certainly through the normal budget process, is making sure our incident response agencies and our incident response teams and our investigative teams in our field offices have the resources necessary to be able to act on that level of reporting. So it's not so much the ingest, but we want to make sure that once we're in receipt of that and we're pushing out those leads to our 56 field offices, we have, for example, for us, the cyber squads and the cyber task forces in place that are going to be able to do that immediate response that we're all aiming for.
There is also reportedly an executive order in the works that may be out by the time this actually airs, that would require software vendors that have government clients to report data breaches to their government customers. And since we're talking about large software companies, are almost all of them are government customers, to what extent do you think something like that would cover 80 to 90% of the kind of reporting you are really looking to see, Adam? I know, just speaking hypothetically.
Yeah, I think that helps, but the government, I don't know that we consume every or nearly enough of the products to know that forcing it through procurement contracting, I think, is the model you're using. That is a powerful tool, and it always amazes me whenever we have an incident. We check the files and we're like, we might be able to do something with this, and we tweak that. And so the one job I think I probably don't want is a government procurement contract lawyer, because I feel like you're constantly updating those forms. I think it helps. I don't know, though, that it gets at everything. So another category of information, Tanya mentioned critical infrastructure. I think bottom line, you want the government to know, I think, if there's something that threatens pieces of critical infrastructure, because even if it's not our responsibility as a regulator, as DOJ and FBI in a particular state, right? A lot of critical infrastructure things we think about, power plants and the like, they're under, state regulation or a mixture of public and private and the like. You still want to know about it because you want to warn the sector. So that's one thing. Another example is export controlled information, right? You don't want technical data that has a sort of military application to go out the door without us knowing about it, because you want the military to know what's been exposed. There are other examples where there's a public benefit to for us knowing about it, even if it seems like a purely private event. But that's why I think the sort of sausage making that has to happen in the policy process to figure out exactly how to scope that.
Right. No, that makes sense. Let's talk a little bit about some of the concerns that people have raised about this potential legislation. You do hear from civil liberties advocates saying that, will this open up a new avenue for the government to access personal consumer information from companies, personal messages, things like that. Either Adam or Tanya, would you have, what would you say to people who raise those kinds of concerns?
Yeah, I think to be clear, the kind of reporting we're talking about isn't of that kind of sensitive personal data or the like. We're looking essentially for the fact of an incident and the basic parameters to understand what our response posture should be. And then for that kind of information that you'd worry about from a privacy perspective, that could very easily require legal process, right? So this would not make it any easier for the government to get that kind of information. In fact, if I could, there's a conversation happening right now about, how do you not have a SolarWinds type event happen again? Does the government have enough information? I think everyone who works on cybersecurity agrees that the government, needs some more insight into what's happening on private networks, because that's the majority of the internet. So if you want us to respond, we can't respond to what we don't know about. There are a couple ways you could give us that visibility. One option that I've heard called for is more, monitoring by components of the government, like the intelligence community. One alternative to that, if you don't like the idea of more surveillance, is reporting. Reporting that is voluntary in the sense that you choose what you put on the form that you fill out. Now, the regulation may require it, but the point is you're filling it out. Someone's not watching your network. And so, if you don't like warrantless surveillance, I've got a bill you might like.
Luke, what about what about on the liability side? You had mentioned the Ohio model as a potential way forward in terms of the kind of liability protections that you'd like to see. Can you talk a little bit more about that side of things? How important is liability from lawsuits?
Yeah, it's a very big issue, Aruna. And this is the other side of the coin. For most of our clients, there really isn't, certainly in the US, there isn't a concern about DOJ or FBI, viewing them in the wrong light, by and large. It's very rare. It is on the regulatory side and the civil litigation side, to your question. The regulators, they have a different agenda. And sometimes a victim coming forward to report something to law enforcement feels like they're pointed at as the perpetrator by a regulator. I think things are evolving, and the more sophisticated regulatory agencies in the cyberspace are coming to realize, how complex some of these issues are. I can tell you, I don't think we're there in other parts of the world. Much of the rest of the world has been very focused, rightly so, on privacy issues, much less on cybersecurity issues. And so regulations like GDPR, they have one phrase on cybersecurity, that it has to be reasonable. Well, that's very speculative, and beauty's in the eye of the beholder there. So the regulatory exposure is an issue. civil liability is an issue. We've seen erosion of attorney-client privilege in the courts. We've seen courts basically, they've taught the plaintiff's bar how to get past the motion to dismiss, how to plead harm, even when, no one can show that their data was misused, for example. Those cases used to be thrown out. And now it means that you're past the motion to dismiss and you're into discovery. And that means they're asking not only about this incident, but they're asking about the risk assessment and the pen test that you did last year, what you knew. So there's a lot of consequences to these things. And I think if we could get a little more nuanced in our regulation and our laws about incentives for good investment and good behavior, understanding that everyone can't control everything in the cyberspace, that would be a healthy step forward for this type of regulation.
So I think we have only a few minutes left, and so maybe we'll just go down the line, and everyone can offer their kind of final thoughts and what is the takeaway that you think from your agency perspective or from the private sector perspective. What is it that you want Congress to keep in mind as they think about trying to craft this legislation? Tanya, maybe do you want to start that?
Sure. So I think we've seen a lot of positive developments recently in terms of the conversation around this. We've seen some really helpful thoughts from the Cyberspace Solarium Commission, which has been successful in getting many of their recommendations taken up in legislation, and they continue to advocate for other of their recommendations, including the National Data Breach Reporting Law, as well as the type of incident reporting we've discussed related to critical infrastructure. And of course, since SolarWinds, we're seeing this greater conversation. So I think it's an important moment where an effort like this might succeed, where others have failed. I think the important thing to emphasize, or an important thing to emphasize, is I think some may look at this and say, well, that's great that this increased reporting would tell you about things that happened after the fact. That's great for data collection and looking at trends, but we really need to be getting ahead of threats. I don't think it's an either or. I think for a lot of the reasons we've discussed on this panel today, having this type of greater visibility would not only enable us to better understand what's happened, but would give us clues that would help us prevent additional harm from happening. These cyber incidents, they're not one and done. They're often a series of victims and ongoing campaigns that can last months and years if they're not stopped. And so I don't think this should be looked at solely as an after the fact reporting. This type of information is really critical to helping us get ahead of threats as well.
Luke, do you want to go next?
Sure. I think I agree with Tanya. We've got some momentum. People didn't really view law enforcement, DOJ, FBI as terribly helpful when they came to them some years ago because information wasn't coming back, threat intelligence wasn't coming out, and people really didn't understand how they were viewed when they came forward to law enforcement, and that's changed. And it really is DOJ and FBI, Secret Service leadership, and now DHS playing a huge role as well, that have spent a lot of time and effort educating the private sector on the value of coming forward. I think not only is it beneficial in the vast majority of cases because of what you learn back in terms of threat intelligence, but I think it's increasingly expected by your stakeholders, your shareholders, your board, your customers, legislators, that they expect that you try to do everything you could by your customers and came forward. The question is, how do we go to the next step? How do we deal with this patchwork of state laws? Can we simplify that? Can a federal structure or law do that? And how can we create incentives for even better investment in cybersecurity?
I think the two takeaways I'm getting are one from Tanya, which is this sells if it feels like it has a preventative or prophylactic benefit. That if it's only about historical trends or understanding what's happening on the internet, that's not going to necessarily be the value add. But I think what you get from this kind of reporting that you may not get from a broader program of data collection by an agency like surveillance is, you've got someone raising their hand and saying this is abnormal. When you're collecting data and you're trying to hunt for what the threat is, you've got to filter that, and it's like an intrusion detection system, right? It really only tells you what you already know is bad, whereas this kind of reporting focuses you on, makes it easier to find when there's actually been a breach that matters. And from Luke, there's got to be a way to make this so that you're not worse off by sending the report in, right? Not, it doesn't hurt you. And that, I think, in terms of whatever regulation or whatever regulators are going to do in response, this kind of report that we're asking for, you don't want it to be something that leaves you in a worse position than you were. That's the first rule of law enforcement when we report to a breach is first do no harm. And I think this kind of reporting has to follow the same rule.
Well, I think that takes us to the end of our panel today. Thanks, everyone, for joining us. Great conversation. Thanks a lot.
Thanks, Aruna.
Thank you.
Thank you.